Good afternoon, everyone. Welcome back to Business Law 2. Today we're going to be looking at Chapter 50, which involves employment law. Some of the overall learning objectives that I want us to kind of cover as we review this chapter. Understand how common law employment at will is modified by either common law doctrine, federal statutes, or state statutes. We'll talk about various kinds of prohibited discriminatory practices under Title VII. And then we'll look at various pieces of federal legislation that's designed to protect age as well as persons with disabilities, physical or mental. So that's the overall kind of like focus for this chapter. Anyway, when we talk about the different types of workers that work at a company, this chapter we're focusing in on employees. We're not talking about agents. We did a chapter where we talked about agency a few weeks ago, and so employees lack certain powers. So like the ability to enter into contracts like an agent does that binds a principal or the employer. But employees generally are hired to further the interests of the employer. They're usually under direct supervision or direction. So they're told what to do or not to do, and they're told how to do certain things. That's part of being an employee. Under the employment at will doctrine, employers generally can terminate employees for any reason or no reason at all, as long as it's not based on some discriminatory basis. So that's generally the rule for most positions here in Florida, that this idea of employment at will, so that an employer can tell a worker, it's like, well, I no longer need your services, so we're going to terminate you. As long as they're not doing that to all like elderly workers or all female workers or all non-white workers. If it's just random, then there's a lot of power that employers have in that regard. The flip side of that is, from an employee perspective, we have the ability to just, summarily say, okay, I'm giving you my 2 weeks notice. I don't want to work here anymore. And so, it does provide flexibility there from the worker perspective. You're not locked into a contract that would prevent you from leaving, a certain employer. So, like with anything, there's always pluses and minuses for this. The Civil Rights Act of 1964 had different titles or sections to it. Title VII deals with discrimination, and so this legislation prevents employment discrimination that's on the basis of race, color, religion, sex, or national origin. The federal agency that's tasked with investigating any violations, or alleged violations, I should say, of Title VII would be the EEOC. That's the Equal Employment Opportunity Commission. Two types of situations that arise in the employment setting that have discriminatory, tones to it is this idea of disparate treatment versus disparate impact. Disparate treatment, exists where an employer treats some individuals less favorably than others because of one of those things, race, religion, color, sex, or national origin. What's critical if you're trying to bring a case involving disparate treatment is you have to establish that there was some discriminatory motive. That's really essential to your case. And that can be hard. You're kind of getting into the mind of, whoever's making these decisions. And unless there's some kind of confession or you have some specific evidence, that could be, from an evidentiary perspective, problematic to prove beyond a doubt. Disparate treatment, this involves employment practices that make no reference to any of those categories, race, color, religion, sex, or national origin, but have an adverse effect on some protected group. So the employer has to show that there is some job-related necessity for the practice that they're being accused of. And lack of intent is not going to be a defense for this type of disparate impact. So, let's say that, a woman is not hired for a position, let's say in a warehouse. And, maybe the mindset is that, oh, well, this is man's work, in terms of what's expected. If it's a bona fide occupational requirement, maybe you have to be able to lift 100 pounds in order to successfully do this job. And that's not an arbitrary thing. That is something that you can demonstrate, regularly. These employees have to lift things that are 100 pounds or more. And so if you do not hire a woman, that's obviously a negative impact. But if you're applying it to everybody, then you minimize that disparate impact. There are plenty of guys that can't lift 100 pounds, and so that is what we're really looking at. Is it being applied equally, or are you just kind of making up things in order to filter out some group you do not want to work there? The protected classes, excuse me. So obviously race or color-based, concerns. Non-whites are definitely a protected class because those groups have been the most disenfranchised, along with women, so as a gender. Religion, what we look at here is reasonable efforts of accommodation, religion does deserve protection. A lot of times this comes up in the area of like observance of religious holidays or celebrations. So normally employers have to work with employees in order to kind of reasonably accommodate the celebration of different religion and religious holidays. Whether it's, think of like, Ramadan or Kwanzaa or, Christmas for Christians, every major religion seems to have special times or celebrations for different, religious reasons. And, as long as it's a reasonable accommodation, maybe you have to adjust your schedule. You have to be out one day, but you can maybe make that up on a different day or whatever. Those would be reasonable accommodations that an employer would be expected to provide. When we get to the topic of sexual harassment, there's essentially two broad categories of sexual harassment. There's quid pro quo, which is, Latin is something for something. And that's where an employer or someone in a supervisory position says, well, unless you perform some sexual service on me, you're not going to get, fill in the blank, a promotion, or maybe you're going to get fired, or, obviously something negative. And the reward is, if you do this for me, whatever this sexual thing is, then you keep your job, you get a raise, you get a promotion, whatever. That's quid pro quo. That obviously is a form of sexual harassment. There's also the idea of a hostile work environment. And so, if any of you I've worked in work environments where this has occurred, where a supervisor or someone in management is dating an employee. And even though the couple is not directing anything towards the group itself feels harassed. One, they have to witness, if there is things that happen in the workplace. But then two, you can't help but wonder, it's like, well, if someone's going to be up for a promotion, who is likely to get that promotion? Is it going to be the supervisors, whoever he or she is dating, or is it going to be someone else? That would be an example of a hostile work environment. Another example of a hostile work environment is, let's say that, maybe you have a group of bawdy guys and they're making, sexual jokes, and maybe distributing, memes or emails that are of a sexual nature, and they aren't directed, let's say, towards any female in the department. But as a woman in the department, just the fact that you are seeing or hearing these things, that's a hostile work environment. That's not, like boys will be boys. And obviously that is an environment where you feel harassed in a generalized sense, even though you're not necessarily being targeted for this type of harassment. It still is harassment nonetheless. There was a case, this came up in the early 2000s. It was Amanda Lyle versus Warner Brothers Television Productions. And it highlights limits to this idea of sexual harassment. Amani Lyle, worked on the set of Friends, and she was one of the assistants that worked with the writers on the show. And the writers on the show, behind the scenes would brainstorm every week for new script ideas. And a lot of the ideas they initially came up with were very graphic and very sexual. And so Amani, her job was to kind of record all of these ideas, because you don't know what's going to make its way into the script for the show. And so eventually she was terminated. She was only there a few months, and then she was fired. And she felt, upon reflection, that she was being harassed by listening to all of these very graphic, very, things that they knew would never make it in a script, like let's say sexual assault. That's not something that, a sitcom is going to incorporate in its storyline. And so she ended up suing because she felt that, she was terminated because, she, obviously it was clear that she was uncomfortable with the discussion that a lot of these writers were having. Anyway, the case went to the Supreme Court for the state of California, and the Supreme Court in California unanimously found for Warner Brothers, that was, kind of like the company that was kind of employing these writers. And they argued that because of the artistic nature of writing scripts, and the fact that it was a sitcom that involved younger persons that were sexually active, that it wasn't unreasonable that in that work environment, you would be saying things maybe that were very shocking of a sexual nature. Now, this presented a limit to sexual harassment cases, but it's a very unique, very unusual environment. You wouldn't be allowed to do this if you worked in an insurance office, or if you worked, at Starbucks, I mean, so the idea that, you can actually engage in these types of very bawdy discussions, the California Supreme Court has said it's okay, but you have to be in this creative environment that is, kind of delves into that topic. So it is a fairly restrictive, type of ruling, but it does kind of reflect a challenge that we face. It's like, we want, artisans, whatever their craft is or their medium of expression, to be unfettered and be able to disseminate their expression. But we also are trying to balance that. We don't want their expression to end up violating the rights of others. So it's a very, very challenging area of the law. When it comes to gender or sex, generally status as a woman, you have protections in place. Sexual orientation and identity is a different issue. The Supreme Court over the past 2 years has heard a couple of interesting cases. The first case was Bostick v. Clayton County, Georgia. Here, a county worker was fired because the boss discovered that the employee was gay. And there was no other reason for the termination. It wasn't poor work performance. It was the fact that the boss did not want to work around a gay person. So obviously, Bostick, he files suit and he says that I'm being discriminated against because of sex discrimination. An unrelated case, but kind of dealing in the same topic, is Harris Funeral Homes versus the EEOC and Amy Stevens. Amy Stevens worked for a funeral parlor in Michigan, and as a funeral director. And Stevens originally was a man, and told the funeral parlor owners that when he came back from his 2-week vacation, he was going to be a she and would now be referred to as Amy. As soon as Stevens came back and was a woman, the funeral parlor fired her because they said men do not dress and act like women. So again, sex discrimination, but it's a different facet of sexual discrimination. Gender or sexual orientation versus gender identity. Interestingly, the court found for Bostick and for Amy, they interpreted the Title VII requirement of a ban on sex discrimination to include sexual orientation as well as gender identity. It's still not really clear, though. I mean, these were kind of narrow decisions that were made. There is no clear kind of like federal law that protects, the civil rights of persons who are of the LGBTQ community. And we see there still are attempts to engage in a lot of discriminatory practices against members of the LGBTQ community. But these were significant wins nonetheless, in that, it did kind of clearly kind of say that, even though sexual orientation and gender identity were not listed in Title VII, we're going to interpret the idea of a ban on sex discrimination to include not just a gender, female, but it's also, who you're attracted to or what you identify as. So there is progress that's being made with regard to rights for these individuals, but it's not a perfect kind of system that where all the rights are always going to be strictly enforced. But two interesting cases nonetheless. So this is just a theories of discrimination, disparate treatment versus impact, sexual harassment, and then the exceptions. I won't read all of this, but it's a good summary to kind of provide this overview in terms of these employment issues. If a state EEO agency or the EEOC, the federal agency, if they're not able to resolve the case, then what is issued by the EEOC is what is called a right to sue letter, and that's what enables a person to go into federal district court and sue, let's say, an employer, for example, for sexual discrimination. If you don't have that right to sue letter, the case will just get dismissed because it's not ripe, it's not ready for litigation yet. Courts would rather have the EEOC try and figure out if there can be some sort of amicable resolution to the dispute before it ends up being litigated. Some other miscellaneous issues related to Title VII violations. An affirmative action plan is legal under Title VII, provided that it's a voluntary plan and it's designed to be a remedial measure, and it doesn't unnecessarily hinder the interest of the majority, meaning like whites, in a particular employment setting if we're dealing with race as an issue. Remember, affirmative action is this policy that started in the 1960s to give preferential treatment to previously disenfranchised groups such as women or non-whites when it comes to academic placement in, like, let's say, graduate programs, or if it's in the employment setting for hiring and promotional decisions. Defenses. So this is from the employer perspective. If it is a bona fide occupational qualification, the key thing is that it has to be reasonably necessary to the normal operation of that position in the company. Maybe it's job-related, professionally developed ability tests. So that could, again, it has to be tied to job functions. It can't just be some random thing that we say you got to pass this test. Or if we're talking about bona fide seniority systems. And so, in certain employment settings, they have, like for promotion decisions, they have a seniority system that's in place. So it's kind of like who's been there the longest, they're the ones next in line for maybe some sort of promotion. And so if that's well established, then those would be defenses that could be offered. Employers have, have a permissible affirmative action plans, ones that have this. Again, it has to be remedial in nature, voluntary, usually temporary. One thing that, can kind of result from these types of affirmative action plans are allegations of reverse discrimination. And that's really a challenging case in order to prove. So essentially, this is a white person that is, accusing that because they're white, they're now being victims of discrimination for no other reason than their skin color. And again, that can be a very, very difficult case to prove, especially if the company in question has this affirmative action plan, or if they're trying to kind of right for previous wrongs. I think the stereotypical fear is that, well, I'm more qualified because I'm white, and I'm a guy, and someone else is just getting that promotion or something because, they're previously, that group has been disenfranchised. When in reality, I mean, these usually are all very qualified people, and if people are in general similarly situated, why not hire someone from a group that has been previously disenfranchised in the name of advancing diversity and affirmative action? But I get it. I mean, it's very, you're dealing with, careers, and you're dealing with people's livelihoods, and emotions run high. I get that. But again, the whole point of Title VII is we're trying to right all these historical wrongs that have occurred with all these groups. It's not a perfect system, but we've got to figure out a way so that we can pursue and advance diversity and opportunity for all, because that really is the key thing when you think of anything civil rights related, is that people just want to be treated the same, and they want to be given equal opportunity to be successful and not be hindered because of, their gender, or because of their skin color or something like that. They can't change generally. In terms of some other EEO laws, there's the Equal Pay Act. Employers must not pay employees of one gender a lower rate than the rate paid to employees of the other gender for substantially equal work. There is, however, a bunch of exceptions to this. If it's a seniority-based system, if it's a merit-based system, if there's some sort of earnings that are tied to quality or quantity of output, then that generally will be permitted. Unfortunately, I mean, even to this day, women on average earn anywhere from 15 to 20% less than men do for comparable positions in the workplace, and for no other reason. It's a shame that things are like that, but the public sector seems to have done well in this area, because if you've known anyone that works for government, when you look at compensation, it's always going to be based on what is the highest level of degree that you have earned and what is the years of experience you have in this position. It doesn't matter anything else, your age, your gender, your race, your religion, nothing, doesn't matter. The public or the private sector, they have not gotten to that point yet. They still want to be very secretive in terms of how employees are compensated, unfortunately, but the public sector has figured that out, and it's very transparent. The ADA is the Age Discrimination in Employment Act, and so workers over 40 years old are protected from discrimination. Again, if you're not targeting someone over 40 and you got to do layoffs or like a reduction in force, if you just randomly do it, there's going to maybe be some people over 40, some people under 40. But if you're intentionally selecting just older workers, that's going to be a problem. The Americans with Disabilities Act, this is an extension of civil rights protection that was passed in 1990. And the idea here is to protect persons with physical or mental disabilities from discrimination in the employment setting. So under the ADA, employers must make reasonable accommodations as long as it doesn't reflect an undue hardship. So, I'll use myself as an example. If I wake up tomorrow and I lose my eyesight, I no longer can see, that obviously is a physical impairment. I'm blind. Can I still be a professor? That's the question I usually will pose to students. And the answer, of course, is yes. I mean, there's going to be some challenges associated with me continuing to be a professor. But, from Valencia's perspective, I mean, they could get me a Braille keyboard and mouse so that I can still communicate electronically with coworkers and with students. I certainly still have the ability to talk. I still have my mind and my sensibilities, so I can still, discuss topics. I can still answer questions. I can talk on the phone. There's still so many things that I can do, and those accommodations are not that expensive. If change the facts a little bit. Let's say I was a lifeguard and I lost the ability to walk. So I'm confined. I can no longer walk. That's going to be hard for me to maintain being a lifeguard, because it involves running and swimming and rescuing people and pulling them out of the water, and you really do need full set use of your legs in order to successfully do that. So there are limits to the ADA. We're not going to have employers expend an excessive amount of money or face some sort of undue hardship. The type of activity that is defined as a disability is anything that substantially limits a major life activity, so that it can include seeing, hearing, speaking, walking, breathing, performing manual tasks, learning, and working. So it covers a broad area there. Concerning just in general the regulation of employment, so like justifiable discharge, in any one of these listing of examples, employers are going to be justified in terminating the employment of that worker. So non-performance, misrepresentation, disloyalty, theft, possession or use of drugs, misconduct, incompetence, those are all examples where it's going to be justified. Reduction in force, and unfortunately we've seen a lot of that, in recent year or this past year. Employers can lay workers off for downturns in the economy. Again, the decision cannot be based on some form of discrimination. You have to kind of equally, distribute the pain, so to speak, so that you're not impacting just women or just elderly workers. It's distributed equally. So, under SOX, there is a whistleblower protection provision, and so it prohibits any publicly traded company from taking adverse employment action against an employee who testifies or alerts the SEC regarding, maybe some sort of fraudulent activity that's occurring at this publicly traded company. So again, we want to try and encourage workers when they see something that's illegal that's occurring to alert lawmakers and regulators, in particular, I should say, regulators, not lawmakers, regulators, so that corrective measures can be put in place and we can stop that activity from occurring. When we think of employee duties in terms of whatever is specified in a contract, if you are in a profession where you do have a written contract, you can provide for services. You can have provisions regarding trade secrets and how they have to be kept secret. Inventions, we covered this a little bit, as well as work made for hire when we covered intellectual property in Business Law 1. Remember that if you invent something in the workplace that maybe is unrelated to your job, your employer does have shop rights, meaning they can use your invention. They can't license or sell it to others, but they can certainly use it for themselves. Work made for hire, so if you're hired to create intellectual property, anything you do create, then, that belongs to the company then, because that's part of your job, that's part of your salary. Even if it generates, tens of millions of dollars or billions of dollars, and you're only being paid $50,000 a year, well, that's the nature of why you were hired. Compensation, obviously, workers have to be compensated as per, whatever, their, whatever the arranged agreement is per hour, or if it's a salary type situation. The federal minimum wage is $7.25. The Florida minimum wage, I believe, is $8.56 now, so it's a little bit above what's listed there. But again, if you're an hourly worker and you work above 40 hours per week, then you're entitled to overtime. If you're salaried, normally you're not entitled to overtime compensation in most salaried positions, because you're performing usually what's considered a professional function. So you're in management, maybe you're providing a professional service like, a doctor, a lawyer, an accountant. If you're performing non-professional services, though, this was a case involving Starbucks years ago, managers were being asked to work like a shift in addition to being a manager. Work a shift where they just make coffee or basically at the register bringing out customers, and that was work that was done after they had completed 40 hours as a professional, the manager of that particular location. So since it did not involve professional services, it was essentially what hourly workers do, they actually were entitled to overtime compensation. So it is a fairly nuanced area of the law, and it can be a difficult case to prove if you're a professional. But, again, we look at what is your job duty, what are your specific job functions. These are usually standard signs, and I have it in different languages, but, in any common work area where, it could be a break room, or if there's a time clock, you have to kind of clearly identify, these posters in different languages so that you let workers know what their rights are under the law and what they're entitled to in terms of a minimum compensation if they're hourly employees. Just a couple more slides and we'll be finished. ERISA is the Employment Retirement Income Security Act, and that covers employees that have pensions. And so pensions are kind of getting out of favor because they are prohibitively expensive. Usually where you see pensions to this day, it could be when you work for the federal or state government. But even state governments, even like Florida here, they're trying to transition workers who are public employees out of the pension system into a 401k-like environment so that they can reduce their long-term liability for the fund. So that's just, again, that's just a thing. They're slowly being phased out at the governmental level, especially at the state level. Not so much federal, but definitely at the state level. Excuse me. The last slide here is just some final miscellaneous topics. The FMLA, which is the Family and Medical Leave Act of 1993, that's for employers who have 50 or more employees. They have to approve up to 12 weeks of unpaid leave in the event of birth or adoption or care for a spouse, child, or parent, or personal health condition. The goal is that when you return to work, you either go back to your original position or some reasonable, comparable equivalent. So they can't punish you by saying, you're going to now be the custodian, when maybe you were an assistant manager. That obviously is not going to be permitted. So if you have questions, please feel free to message me anytime, but have a good, safe, and productive rest of the week, and I thank you all very much. Bye-bye.